Hi, everyone. We'll go ahead and get started. I know there are folks that will continue to join as we go, but welcome to our crash course in data privacy. This is truly a crash course. Micole, who's co-presenting with me, will give a roadmap here in a minute, but the topics we're going to cover, we could probably spend an entire hour on almost any single one of these. And so to the extent you've got questions, we'll have a chance to answer some of those. But if you're interested in additional dives into any of these topics, let us know, and maybe we'll do a follow-up on these specific topics. So again, welcome. My name is Will Quick. I'm a data privacy and litigation attorney here at Brooks Pierce. I am a certified privacy professional by the International Association of Privacy Professionals, and a specialist in privacy law certification with the North Carolina State Bar.
And good afternoon, everyone. I'm Micole Little. I'm a 2021 graduate of NCCU School of Law. And since joining Brooks Pierce, I've worked with Will on a number of data privacy matters, along with my intellectual property and media and communications practices. And as Will said, I just want to give you a brief overview of the topics we'll be touching on in our presentation today. We'll be starting off with a look at comprehensive laws, starting with the international ones, which have somewhat become a blueprint for the United States laws that we're seeing develop now. And we'll also touch on potential federal regulation in this area. And then up next, we'll turn to data security incidents and ways to manage those. And finally, we'll touch on some action items that can help put your organization in a better position to deal with data privacy issues as they arise. And as Will said, we'll leave some time for questions at the end, but you're welcome to pose questions in the chat box throughout. And we'll keep an eye out to address any that correlate to the topic we're discussing at the moment.
So before we dive into all of that, just a quick disclaimer. We are lawyers, so we love disclaimers. Obviously, we're giving this presentation on July 13th in 2022. So the state of the laws that we cover is current up to that date. But this is a really fast developing area. The laws do change. Some of the laws that we will talk about, for example, in Colorado, they're undergoing rulemaking right now on the Colorado Privacy Act. We'll talk about some prospective laws. Any of those could become law, and the laws that actually come about could change. So just keep in mind that anything we tell you today is not legal advice. It is information. We look forward to hearing from you if you need legal advice on these areas. Thanks. So Micole mentioned the idea of comprehensive data privacy laws, and so it may be worth a quick overview on what we mean by that. Comprehensive data privacy laws are not laws that are industry specific. We'll talk about some industry specific laws at one point in this presentation. They're not focused on simply breach reporting. We'll talk about those types of laws as well. But generally speaking, these comprehensive data privacy laws speak to consumer rights. They provide rights to consumers that wouldn't otherwise exist, and then outline businesses' obligations with respect to those laws and those consumer rights. Next slide, please. So the first place we'll start today is with the General Data Protection Regulation, which is an EU law. And you might be wondering why start with an international law when we're here in North Carolina, we're here in the United States. The reason is because, as Micole noted, this law has really become a blueprint for many of the US laws that we will talk about further in the presentation. It's also generally applicable to anyone who is collecting information about EU residents, even if you're here in the United States. So the GDPR became effective in May of 2018. It had a pretty decent ramp up. It was adopted in sometime in 2016. And so there was some time to prepare for it. One of the things that the GDPR did that is different to past privacy laws, at least those we deal with in the US, is it has a really broad definition for what qualifies as personal information. It's essentially anything that a business collects about an individual, from the common identifiers that we think of to things like IP addresses, but it could also include something as simple as your interests in a particular product or type of service. One of the other common themes in laws that have followed on the GDPR that is a big part of the GDPR is the establishment of privacy as an individual right. That's long been the case in Europe. They have taken that view that privacy is an individual right. Some of the rights are outlined on the slide. I won't talk about each one of them in detail, but I will hit on a couple of them. The right to be informed, that means you have the right to know what information a company keeps about you. You have a right to access that information that they're keeping about you. A right to rectify or correct the information that a company may be keeping about you. A right to erase or delete the information that a company keeps about you. A right to take the information that a company keeps about you and get a copy of it and take it to somebody else. That's what the data portability aspect means. And that's difficult sometimes for companies because you have to be able to give the information back to someone in a way that they can actually use it, not just keep it yourself. And then there are various rights related to data processing that we'll touch on here in a minute. I mentioned applicability to US businesses. It does apply, at least nominally, across the globe. It would apply to the GDPR would apply to a US business if you're offering a good or service to an EU resident. That's pretty straightforward. It does also apply, though, if you're monitoring behavior of someone in Europe. And that comes into play a lot of times with service providers who are providing, who may be a vendor or contractor for a company that is offering a good or service in the EU. So there are some other ways in which it could become applicable. Next slide. Won't spend a lot of time on these, but there are a series of sort of high-level requirements that the GDPR imputes on any company to whom it might apply. There are a number of lawful bases that you have to collect that data. The most common ones we see are contract and consent. We hear a lot about consent, but it's oftentimes not the best basis to rely on for collecting and processing data. There's a requirement that you institute measures to protect the data that you collect, both technical and organizational. So these are things from cybersecurity measures up through written policies and procedures. It does impute certain requirements on vendor contracts. We'll talk more about that later. You do have to provide notice, oftentimes at the outset, to a data subject that you're collecting data about them or going to process data about them. It does require that you respond. We talked about those rights to access, rights to be informed. If someone wants to know the type of data you're holding about them, you have to be able to respond to those requests within a specific amount of time. You also have to provide notice of any sort of data breach. That's not something that's uncommon in the US, that we have data breach laws here. And then finally, this is the first several bullets here are oftentimes ones that can be done by a company without needing a lot of extra input. But if you're not located in the EU and the GDPR does apply, you do have to have an EU representative. This is someone who's actually based in the EU to serve as your agent. It's sort of like the idea of a registered agent within a US state. There are some exceptions that doesn't apply if you're processing a small scale or if you don't process sensitive data. Next slide. So I included this slide because oftentimes I get the question, well, it's an EU law, why should I care? It can be enforced globally, again, as I mentioned. It is enforced in each member state in the EU by their data protection authority. And so each data protection authority takes a slightly different view on its enforcement policies and procedures. The maximum fine for a violation of the GDPR is 4% of your annual gross income or 20 million euros, whichever is the largest. GDPR has been around a little over 3 years now. It's been in effect a little over 3 years. There are somewhere over 900 fines. There's a couple of different bodies that track these. So the numbers vary a little bit depending on which tracker you look at any given day. Of those 900, I thought maybe just a brief overview of what we're seeing is kind of interesting. Not surprisingly, most are EU-based entities. They range in fines of 100 euros up to several I'll talk about here in a second. But of the smaller dollar ones, I've seen a fine on an individual who was taking photos using a dash cam and uploading that information to YouTube. There have been HOAs in the EU, or essentially like HOAs, fined for taking photos of people's homes and posting those on community boards without the consent of the individuals whose homes were pictured in those photos. And so it really runs the gamut among the fines that have come out. But I guess the good news for US companies is, at least as far as enforcement globally goes, most of that is taking place within EU countries. And of the companies that have US presences that have received fines, they are pretty much a who's who of the biggest tech companies in the world. Several are listed there. For example, Amazon, with a 746 million euro fine, has been the biggest so far. There's a little bit of information there about what that relates to. That was a cookie consent violation. And then the list goes on down to Google, which is at the bottom, with about a 60 million euro fine. As you'll see, a lot of those are cookie consent. That's a big deal in Europe. We're not going to talk about that today, but it's certainly something to keep in mind. I mentioned Clearview AI at the bottom of the list there. That is not a large company and not one that's a household name, but they are a US-based company, and one of the only US-based companies that's received multiple fines from EU data protection authorities. You wouldn't have any reason to know who they are, but what they do is they provide a facial recognition software to companies, law enforcement, universities, individuals, those sorts of entities. Their algorithm matches faces to a database of more than 20 billion images indexed across the internet. And so they scrape the internet, social media sites to collect this information. So what you can do is, if you have a photo of someone and you have Clearview software, you can load that photo and it will run it against their database and tell you lots of information about where that individual might have been. If there was a photo taken and it was cached with information about date and time, you can learn where someone was at a particular date or time. That's of interest to law enforcement for obvious reasons. But at least 4 data protection authorities have levied fines and orders against Clearview AI. Interestingly, they are based in New York, and their response thus far has been that we are not subject to your laws, essentially go pound sand. The most recent, I think, fine was in May of 2022. So this has all happened within about the last year. It'll be an interesting test case as to what extent of authority these EU DPAs have to actually enforce the GDPR globally. Next slide, please. I'm not going to spend, again, time talking through each of these, but I just want you to be aware that there are lots of other comprehensive privacy laws out there, and there are more being discussed and adopted each year. A list of several are here, and so if you do business in these countries, or you have you're a vendor who provides services to businesses that do business in these countries, you might have to become aware of some of these laws that are around the world. Next slide.
So Will just gave an overview of what's going on the international scale, but there's also been some activity in this area in the United States over the past couple of years. We currently have 5 states in America that have enacted data privacy laws, and those are California, Virginia, Utah, Colorado, and Connecticut. And California actually has the distinction of having 2 different data privacy laws on the books. United States comprehensive privacy laws provide many of the same consumer rights that Will just covered for the GDPR and other international counterparts. The language may differ very slightly, but for example, the right to know correlates to the right to be informed under the GDPR. The right to correct equals, the right to rectification, and so on and so forth. And you'll see that there are many common elements used to determine what organizations and businesses are subject to these laws. And as I touch on those individually, I'll try to focus on the distinctions to try to make those a little more clear. But the main differences will be found in the actual dollar amounts required for annual revenue and the number of consumers an organization processes data for. And so those are things to keep an eye on as we look at some of the common triggers that you see in this column to the right of the slide, such as doing business in the state, meeting a certain annual gross revenue threshold, controlling or processing the personal data of a certain number of residents in a state, and deriving a certain amount of annual revenue from selling or sharing consumers' personal information. So we'll start with the California Consumer Privacy Act, which is called, also known as the CCPA. It's been in effect since 2020, and these criteria that you see under who is subject to the CCPA, it's not so much as an all or nothing approach, but there are often certain base criteria, such as doing business in the relevant state, and then a variety of other criteria of which any one will make you subject to the act. So for example, under the CCPA, one of the base criteria is doing business in California that involves processing consumers' personal data. And then any of the three following criteria will catapult you into needing to be compliant with the CCPA. And for this particular act, they are having annual gross revenues of more than $25 million, buying, selling, receiving, or sharing the personal information of 50,000 or more consumers, households, or devices based in California, or deriving 50% or more of annual revenues from selling consumers' personal information. And an important thing to note from the California laws is that California is so far the only state that's providing a private right of action in the event of a data breach that happens due to non-compliance with their privacy acts. So California's second act is the California Privacy Rights Act, which has technically gone into effect in December 2020, but most provisions will not be enforced until January 1st of next year. And you'll see that there's quite a bit of overlap here, which is to be expected, but there are a couple key differences here. The main one is that because it doubles the CCPA's 50,000 consumer threshold for that second criteria option, some small businesses that have to comply with the CCPA may not actually be subject to the CPRA. The CPRA also adopts some principles and obligations from the GDPR, such as data minimization and storage limitations. And those are topics that we'll touch on a little bit later when we're talking about action items. And finally, the CPRA also goes a step further and creates a new enforcement authority called the California Privacy Protection Agency. And that agency is actually in existence now. Up next, we have the Colorado Privacy Act, which goes into effect on July 1st of 2023. And the key difference here is that the Colorado Act includes language that says that it targets businesses that intentionally target Colorado residents. And it also adds on some language that says that if your business or organization receives discounts on goods or services from the sale of personal data of Colorado residents, then that may push you over the line into being subject to the Colorado Privacy Act. Up next, we have the Virginia Consumer Data Protection Act. And this one aligns very closely with the CCPA and the CPRA, so I'm not gonna really dig into the details here. You see the same elements of doing business in the state and controlling or processing the personal data of a certain number of Virginia residents, as well as deriving a certain amount of revenue from processing that data. And like Virginia, the Utah Consumer Privacy Act is very similar in terms of how closely it tracks with the California acts. So I won't get into those details, but this one does not go into effect until December 31st of 2023. And bringing up the rear here is Connecticut with the Connecticut Data Privacy Act. This is the most recent state to adopt a comprehensive privacy law. And some key differences here are that Connecticut requires you to look at the threshold criteria as it applies to the preceding year and not necessarily the calendar or fiscal year that you are currently in. It also, when relating to those criteria, it excludes information that is collected solely in the process of completing payment transactions. So that could make it a little harder for businesses to come underneath the umbrella of the Connecticut Act. And again, keep in mind that California is the only state that's providing a private right of action under these acts. Virginia, Colorado, Utah, and Connecticut do not. So now that we have covered the state laws that are currently in place, we want to draw your attention to some exemptions and limits that are associated with them. California, in apparent California fashion, has two California specific exemptions. The first being that businesses can collect, use, retain, sell, or share anonymized or aggregate consumer information. So basically, data that cannot be linked to a specific individual is not covered under the scope of the Act. The second is that businesses can collect or sell personal information if every aspect of that commercial conduct takes place entirely outside of California. For example, if a certain sector of your business only serves out-of-state residents in an out-of-state capacity, the policies of these acts would not apply to their data. And we also have here some common exemptions that apply more broadly to the group as a whole. And those can be divided into kind of two big buckets. The first of which is entity level exemptions. And those focus more on who is processing and storing personal data and information, such as higher education institutions, nonprofit organizations, government entities and agencies, financial institutions that are subject to the Graham-Leach-Bliley Act, which we'll, I believe, be touching on later, and entities that are subject to HIPAA, for example. And the other big bucket we have here is data level focusing, which focuses on the type of data that's being processed or stored. So the triggers there would be more focused on whether the data is subject to HIPAA compliance, or if it is covered under the Fair Credit Reporting Act, the Family Educational Rights and Privacy Act, the Farm Credit Act, and things of that nature. These are obviously not exhaustive lists. So if you feel that your company or organization is subject to any of these laws, you'll want to take a closer look at those and see what's covered and what's not.
So Micole has run through many of the states that have come out front now and passed laws following California. There are about a dozen other states that have some level of activity or a legislation introduced that follows at some level on the CCPA or models itself on one of the other laws that Micole touched on. What about North Carolina? Well, we do. We have had this past year, there was a Consumer Privacy Act that modeled the Virginia Consumer Data Protection Act, introduced by 3 state senators. They were all members of the Democratic Party, and that bill was sent to the Rules and Operations Committee, where it has gone nowhere. Just in case you're wondering, though, what folks in North Carolina who have introduced the law are thinking about and differences they may be thinking about, there was an annual data assessment requirement in the North Carolina Consumer Privacy Act proposal that was introduced that was a little different than what we've seen in other states. It would require, some of the other states do require data assessment to be done, and we'll hit on that towards the end of this presentation. But there was an annual requirement, essentially, that be updated. Doesn't seem like a horrible idea if you're going to require data assessment that you not just let folks put it on the shelf, but that was one difference that we saw in the draft that was introduced here. Another is, Micole mentioned the private right of action so far is only present in the California law. There was a private right of action included in the Consumer Privacy Act introduced in North Carolina. But again, that hasn't gone anywhere and won't in this particular session, given that we're done. But the North Carolina General Statutes Commission, which is a body that looks at essentially uniform laws or laws that are being introduced in other states and weighs in as to whether or not it makes sense for North Carolina to consider those laws. Its membership is made up of 2 members of the General Assembly and several members who are several lay folks, including law professors, industry leaders, those sorts. They have looked at a Uniform Personal Data Protection Act model that is put out by a uniform laws body within the last year. It appears that particular consideration is not something that they would recommend, but they have begun to look at other state models, particularly the Virginia model, as a possible option. There's been industry and AG office or Attorney General's office input on the consideration by the General Statutes Commission. I guess somewhat interestingly, most of that input has been critical from both sides. So there were comments by a group called TechNet, which is a consortium of some of the largest tech companies and their leadership. There were brief comments from the North Carolina Bankers Association saying that bankers Association or Bankers Association members should be exempted from any consideration under those laws because of their coverage under Gramm-Leach-Bliley and other laws that apply to the financial industry. And then the North Carolina Attorney General's office weighed in and said that there certainly was a private right of action needed, and that there were stiffer consumer protections needed than were present in, for example, the Virginia law. So it's a stay tuned here in North Carolina. We may see movement on that in future legislative sessions. Again, certainly not this year at this point, but a stay tuned. Next slide, please. What might moot any attempt by North Carolina or other states at a comprehensive state level law would be federal action on a comprehensive privacy law. There have been for the past, say, 10 years and longer, but really in the past 10 years, there have been a number of proposals, but very little progress made on a comprehensive federal privacy law. Sticking points to such a law have been the inclusion of a private right of action, and whether or not existing state laws, for example, the California Consumer Privacy Act and the others that we've covered today, would be preempted at any level by a federal consumer privacy, comprehensive consumer privacy law. Those have been holdups that have happened, consistent holdups year after year. There's generally not been bipartisan support for any proposal until very recently. In June of this year, a bipartisan group of House members from Representative Frank Pallone from New Jersey, a Democrat, Kathy Rogers from Washington State, Janice Skakowski from Illinois, and Gus Bulrakis from Florida introduced a bipartisan American Data Privacy and Protection Act that had a hearing in mid-June before the U.S. House Committee on Energy and Commerce, Subcommittee on Consumer Protection and Commerce. It focuses largely on the ideas that are present in many of the laws we covered earlier in this presentation. It includes the ideas of data minimization. So that means companies should, from the very beginning of any service or product they're going to provide, think about ways in which they can minimize the collection of data. There should be privacy by design built into those products and services. So it's not an afterthought. Privacy should not be an add-on. It should be part of the development of a product or service. It includes the rights to access and correction and deletion that we've discussed, in addition to the idea of data portability. And there was compromise on some of the traditional sticking points that have been the holdup in the past. There was a private right of action included in the ADPPA proposal, but it would be dormant for 4 years. It also has an interesting sort of mechanism before you can bring a private right of action that's aimed supposedly at limiting duplicative actions. So an individual has to notify their state attorney general and the FTC before they would bring a suit under that proposal. And if neither of those bodies, the state attorney general's office or the FTC, decides to initiate an action within a certain amount of time, the person can then file their own lawsuit. There was also a limited right to cure built into that proposal, whereby if there is an allegation that someone's violated the ADPPA, the business would have 45 days to correct before someone could file a private right of action. They could still seek injunctive relief, but might not be able to get damages. And then on the issue of preemption, which has been a holdup, there was again some compromise. I think it's interesting compromise and probably likely to be an area that'll have a lot of further negotiation if this law moves forward. It preempted most of the laws that we covered a minute ago and have been passed in states. So it preempts Virginia's, Colorado's, Utah's, and Connecticut's laws entirely. It does have a carve out, a partial carve out for California and their private right of action and a few other sort of pieces of the CCPA and CPRA combo. It also preempts or does not preempt a biometric information law that's present in Illinois that gets a fair bit of attention if you're in the sort of facial recognition type business or fingerprint business. And then there are about 15 other carve-outs for various civil rights laws, student and employee data laws. So the list is interesting and bound to see, I think, some more discussion. But this has been the law that has had the most, I think, support from a bipartisan standpoint. And so it'll be interesting to see if this moves forward. It's currently receiving comments. Next slide, please, Micole. But I suppose we shouldn't leave talking about federal law without noting that while there is not a comprehensive consumer privacy law in the United States, there are various laws that do apply if you're in particular industries, and there is arguably one set of enforcement that applies across the board. So I'll start there. The Federal Trade Commission has long, since about the mid-1990s, used its power under Section 5 of the Federal Trade Commission Act, which prohibits unfair and deceptive acts and practices in or affecting commerce, as a privacy enforcement tool. You might wonder, how do they get there if there is no specific privacy law written into the FTC Act? Well, that act, if it can be used to punish a business who makes a representation about a particular action that affects commerce, but then doesn't follow through. And so many of the laws that do exist require companies to put up privacy policies on their websites. And if, for example, you make a representation in that website privacy policy about a security action related to privacy, but that turns out not to be true, the FTC has the ability to enforce that as an unfair or deceptive practice. The FTC is limited in its ability to enforce that. There are roughly 20 to 30 enforcement actions brought per year. So the number's relatively small, but the impact can be great. And then beyond that sort of comprehensive way of enforcing privacy, even though it's not a comprehensive privacy law, there are a number of industry or consumer-specific laws. Several are listed here. We've hit on a couple throughout the slides. Most of these, if you're in these industries, you are aware that they apply to you. But if by chance you think you need further advice on this, we'd be happy to chat with you about them. I'm not going to spend time going through each of them because they're pretty, again, we could spend an entire day essentially on any one of these. Beyond the industry and consumer specific laws, there are agency rules. There are rules from attorney general's offices at the state level. There are executive orders, both at the national and the state level, that can affect privacy. And then there are some industry rules and guidelines that are not laws, but they have essentially the effect of laws. A good example of that is the payment card industry's data security standard, or PCI DSS. That's a set of guidelines that anyone who collects or uses credit cards or processes credit cards as a form of payment has to comply with, because it's an agreement by the largest credit card companies on how data should be handled. So if you are in the retail industry, for example, you almost certainly have dealt with PCI DSS issues before and have to go through compliance obligations related to that. Next slide, Micole. So we've talked a fair bit about these comprehensive laws that are starting to become the trend. We're going to switch gears here and talk a little bit about data security incidents and the obligations a business might have if you're the victim of an attack or otherwise fall prey to one of these types of incidents. Next slide, please, Micole. There are many ways in which data security incidents come about. They range from the very simple misdirected email where you meant to type something to one person and your autocorrect fills in another name that looks very similar. That is a pretty low-level type of security incident. In most of those, you will know the person who the information that shouldn't have gotten the information. You will know them and can ask them to delete it. You can take steps to feel comfortable that it's not something that exposes information that shouldn't have been exposed to a third party in a way that's going to cause harm. You might have a lost or stolen device or laptop. Maybe that's a little bit higher level. Moving up sort of the chain, large companies that use web vendors to process data occasionally end up in situations where, for whatever reason, on the back end that might not have been secured. We see this oftentimes. Some of the bigger medical breaches have been the result of unsecured web portals where someone may be able to publicly access it, even though it wasn't a malicious attack. It's out there and it's available for anyone who's there to look at it. And then you sort of move into the more malicious type of attacks. We see attacks or we see incidents where internal folks who have access to data misuse that data. Sometimes maybe it's an IT person or an HR person who has access to data, uses it for a nefarious purpose, to go get a loan in the name of somebody else at the company, to apply for a credit card, those sorts of things. That's sort of the low-level version of a criminal inside attack. You might see someone who's working with someone, a bad actor, to scrape data and sell it on the dark web. All of these sort of things happen. And then you go into the idea of malicious cyber attacks. These are the ones that get the most attention. And there are so many variants on these types of attacks. But some of the more common ones that we see, someone is gotten into an email box and is waiting until either a financial transaction's about to happen and they redirect the funds transfer. Someone is able to guess a password because the password, security measures at a company are not particularly strong. Don't use 1, 2, 3, 4, 5, 6, 7, 8, 9 as your password. It is often one that causes problems. All the way to the malware examples that you see with viruses and Trojans and worms that are installed on devices or make their ways onto servers. So really, there are a lot of different types and variants and vectors for these attacks, but it's important that you know sort of that they exist, and that if something has happened, you know what to do about it. And we'll talk about that in a second. Next slide, Micole. We'll just touch briefly on ransomware because it is one of those malware variants that is becoming more prevalent and can have sort of the biggest impact. Ransomware at the basic level is just malware that encrypts or blocks access to someone's systems, and then it's paired with a demand for payment, a ransom demand. Oftentimes we see that these came about through some social engineering or phishing. Someone's entice you to click on a link, enter some credentials, and when you do that, within a few minutes to a few hours, your entire network is locked up or device is locked up. The ransoms can range wildly from a couple $100s up to millions of dollars. The bad actors who perpetrate these oftentimes have, much like insurance tables, help insurance adjusters know how much they should charge a company for a premium. There are tables that exist to help the bad guys understand how much they ought to charge in a particular ransom situation. Usually you have to pay these in some sort of cryptocurrency like Bitcoin. An interesting variation on ransomware that didn't exist or wasn't that prevalent about 10 years ago, but sort of become more of the norm now, is the leakware or doxware variation. Lockbit 2.0, you see a screenshot there of a Lockbit 2.0 ransom screen. That's an actual screen the client saw. And the very bottom line in that at the bottom says, to recover your data and not allow data leakage, you have to make this payment. Well, it used to be that ransomware was simply encryption and locking of your devices. And if you could recover without paying, that was great. If you paid and got back into your systems, that's got issues with it, but at least you felt somewhat comfortable that what was happening wasn't exfiltrating data from your systems. The variants that we're seeing now, almost all of them have the capability of exfiltrating data. And why that's important is that no matter what happens in that ransom situation, you probably also have a data breach. Your information has been exfiltrated by someone who is clearly there to do no good. And so many of the reporting requirements that apply are going to apply to you in a ransom situation with this kind of that kind of variant. The question that we get in a lot of these initially is whether I ought to pay or should I not pay. You know, preferably you can recover from a backup and don't have to pay. But it's also important to remember that paying might subject you to further enforcement by or further interest by law enforcement. The U.S. Department of Treasury's Office of Foreign Assets Control and the Financial Crimes Enforcement Network have released statements saying that paying these ransoms is likely illegal because it's funding certain foreign criminal operations, including those of individuals or entities on terrorist lists. So it's important, to sort of consider the broad spectrum of potential outcomes if you do pay in these situations. Next slide, Micole. Also we included a slide on business email compromise. This can come about a number of different ways, but what we're seeing in these instances is essentially someone getting into a transaction and absconding with funds, getting funds wired to a bank account overseas, having someone change payroll information for employees so that payroll, weekly or biweekly payroll is being sent to an account that is not the account of your employee. Again, different variants of how this can occur, but there's starting to be more litigation in this area around the issue of who's responsible for these lost funds. And there have been some interesting developments. Essentially, there's sort of two different ways these cases can go. One is the imposter rule that essentially says that whoever had the best chance to stop the fraud from happening is the one who should suffer the loss. And so let's say in a business-to-business type scheme where you owe $250,000 for some product or products that you paid for, and someone gets in the middle of that transaction and the funds are wired to the wrong place. Well, it's very fact specific as to where the bad actor got into that transaction, and where they got in could inform who had the best position to stop that particular fraud. Other courts have taken a more strict contractual approach, and when you owe money to someone and it goes to the wrong place, you had the responsibility to ensure that it was going to the right place, and there's very little sort of sympathy for the idea that that the breach might have occurred on the other side. Speaking of breaches, oftentimes these are also data breaches because if someone has gotten into your system and is able to sit there and wait until a financial transaction has come about, they probably have the ability to also scrape data. And so it's important to think through whether or not you have reporting obligations. Next slide, Micole. Just like with the comprehensive laws that we covered early in the presentation, there are data breach or identity theft protection laws in each state, and similar to the start with California, these laws mostly popped up after California adopted in 2003 the first data breach or identity theft protection law. The last law that was adopted was in 2018 by Alabama, such that now all 50 states have a law that requires the reporting of data breaches at some level. There are variations in these laws. there are commonalities, but there are also variations. So the types of data that is covered under the personal information definitions in these laws is pretty similar. Most cover social security numbers, credit card numbers, driver's license numbers, sort of identifiers like that. But there are exceptions. So to give you some examples, North Carolina includes name plus fingerprint. Florida includes a username or email address plus a password that could access an account. North Dakota includes simply name and date of birth. They're one of the few that includes date of birth as personal information that would trigger a reporting obligation. Colorado includes student identification numbers. So there are little variations in what qualifies as personal information that's important to be aware of anytime one of these incidents occurs. There are varying deadlines on when reporting has to happen. For example, Vermont has a 14-day preliminary notice to the Attorney General's office in Vermont. Florida has a 30-day requirement for reporting to consumers. There's a number of states that have 45-day deadlines for reporting. And then the vast majority say without unreasonable delay. But within those that say without unreasonable delay, there are some soft deadlines that are tracked by the regulators in those states. For example, Indiana has a 30-day soft deadline that if you have not given notice to the AG's office within 30 days of when you say a breach was discovered, they will almost certainly follow up and have additional questions. The methods that those notices can be given in to consumers vary. Almost every state allows written notice, or every state does allow written notice, but some allow other means. Some allow telephone, for example. Some allow email, but with requirements that vary as to when and how you can give that email notice. The content of notices can vary. Most states have some pretty common requirement that you describe the breach, but Massachusetts, for example, prohibits you from giving information about how the breach happened to consumers. So you have to almost always write a separate letter for Massachusetts. There are just little variations like that that have to be monitored depending on which states are in play. There are monitoring requirements for credit and identity protection in certain states. For example, Connecticut requires you to provide identity monitoring if social security numbers are exposed. California says that if you have to give identity monitoring to anyone in any state you're giving notice to, then you must give notice to California residents as well. Or must give identity monitoring protection to California residents too. So again, it's just slight variations on how these laws work. And then finally, there are regulator reporting obligations that are present in many of these statutes. Some require that you give notice if anyone in their state is affected. North Carolina is one of those. The vast majority that have a regulator reporting obligation have triggers based on the number of individuals that you might have to give notice to. Those threshold numbers can be as low as 250, and in several states they're as high as 1,000 residents of that state. There are different timing requirements for when you have to give notice to regulators. Many have online forms now that you have to use to give those notices, and so it is not always a one-stop thing where you can write a single letter that will work for every regulator. You're having to vary those with each individual notice that goes out. And then finally, some of these data breach laws also do carry private rights of action in them. Not many do, but some do. So it's important to be aware of that. Next slide, please, Micole. Briefly, just will mention data breach litigation. It is relatively rare still, but it can happen. It tends to follow the more high-profile breaches, several listed here. When you do have a data breach lawsuit, it's quite often a class action lawsuit, and the theories of harm can vary pretty broadly. Violation of data protection laws, like these laws we've covered today, is a common theme, but you also see breach of contract based on the idea that sometimes a web privacy policy, for example, is a contract that your business has said you will do these things, and now you violated it. Very similar to the idea of FTC enforcement that we covered earlier. Negligence claims or negligence per se claims. Negligence is pretty straightforward. A negligence per se claim is one which says you must be negligent because you violated a state law. And so you'll often see that, or a federal law that protects privacy. You'll see that paired with a breach of or a violation of a specific law claim. These lawsuits, one of the reasons they're relatively rare is that it is often difficult for plaintiffs to make it past the standing phase, which is required, at least in federal court. You must have standing before you can bring these lawsuits. The reason for that is that it is hard to establish that someone's actually been injured from a particular breach. And that's a requirement in federal court. You have to be able to show that you had injury in fact. Oftentimes, an individual actually won't know that they've been harmed. There's been no actual identity theft yet. And so they're claiming that the harm is the risk of future identity theft. Some courts are willing to accept that argument, but many have not been. The other issue that often makes it hard for plaintiffs is that even if they have been harmed, it is difficult sometimes to show that harm, let's say an account was opened or a loan was taken out in their name, was the result of a particular incident. There are statistics that sort of say 1 in 3 individuals probably has been part of a data breach at some point in the past. And so pointing to a particular incident to say this is the one that caused me harm can be difficult to do. Employee lawsuits have a little more legs sometimes because of the agreements you have with employees. If their data is breached, there may be a little bit more ability there to challenge that in court. And then we've covered a little bit of the idea of business-to-business lawsuits and the business email compromise sort of scheme, but those do happen and are something to be aware of. Next slide. Cool. So we'll wrap up now with some things that different businesses and organizations should be doing to help protect your data, to help become more secure. These are high level, but useful for almost any type of business, no matter what level you're at. Next slide, Micole. The first thing that's important to know about your before you undertake any sort of action to protect your data is what data you have and where you keep it, what you do with it, who has access to it. And so doing a data assessment or taking a data inventory is usually the first step in becoming more secure and having a better security posture. These assessments or inventories are often are required by several of the comprehensive privacy laws that we've covered today, and are likely to be included in many going forward. Both the North Carolina draft that we discussed and the ADPPA have the idea that you have to know about the data that you hold and be able to tell, for example, someone who has questions, a consumer has questions about the data you hold about them. You have to be able to tell them where that data is and what you do with it. It is not an easy process to undertake. It takes buy-in from folks in many departments. It's not an IT only type type activity. You have to have your customer-facing departments. You need to be involving marketing and HR and finance and your C-level executives in this process to really understand what sort of data you hold and what you're doing with it. There are third-party consultants that are out there that provide, for example, software that you can add on to your systems to map where your data goes. So if you have, a customer resource management type portal, and then that data it moved from the CRM to another interface, there is software that can track how that is happening and can be helpful and actually help data mapping.
So now that Will has kind of gone over pretty much everything that can go wrong, we want to provide you with some ways that you can guard against those things and mitigate potential damage from a data privacy incident. Many of these policies and procedures are similar to one another. There's lots of overlap with these 4 things that I'm going to list out for you, as well as some of this information that Will has just provided. But implementation of these policies and procedures is meant to provide a level of redundancy and help ensure that things don't fall through the cracks with something as important as sensitive personal information. So the first of these is a website privacy policy. And the rule of thumb here is that if your organization or company has a website, you should have a website privacy policy published. And some elements to include in that policy include, being clear about what types of data you're collecting from consumers, spelling out how that data is used. For example, if your website tracks cookies or uses cookies to track internet activity, and how you implement your data storage and security policies. You also want to clearly outline opt-out procedures and provide accurate company contact information for consumers who, under some of those comprehensive privacy laws we discussed earlier, may want to exercise those consumer rights. And finally, website privacy policy is basically a living document that should be updated and changed as circumstances change. So updating the effective date whenever you make changes to your policy is always a good rule of thumb, so that you and the consumer are on the same page in terms of how current your policies are. Second, we have a written information security plan, also known as a WISP. And a WISP is basically a written document that details your policies and procedures around protecting confidential consumer data, how you protect it, and who is responsible within your organization for ensuring its protection. And a WISP should be followed by anyone or any company that has access to sensitive client or employee information. Many states actually do require a WISP, and Massachusetts is probably the most stringent with regard to WISP requirements. So if you're doing business there, you absolutely want to have one in place before any trouble arises. But California, Oregon, Texas, Rhode Island, and Illinois also have WISP requirements at this time. Third, we'd like to talk about an incident response plan. And this plan should basically answer the question of, what will your business do in the event of a data breach? So a robust incident response plan is one that you're going to have to assess and update regularly. You might even consider testing or having a simulated data incident so that you know where you might have areas to improve. Ideally, a response plan will clearly outline roles and responsibilities for all levels of the organization. And that includes things such as summarizing key regulatory requirements for each jurisdiction that you operate in. And this is particularly important with some of those comprehensive policies such as the CCPA and the Virginia laws and the Connecticut laws, because you want to be aware of when you reach certain thresholds that will trigger those state privacy laws that we discussed earlier. You also want to clearly define severity ratings and triggers that might be cause for escalation to your legal team or your senior management. Because, for example, if an employee loses a phone that has company data and information on it, that may be a simple matter of getting IT to remotely wipe the phone. But if you have a ransomware or a malware issue, that might be a all hands on deck type of situation. Finally, data retention schedules. Those are put in place so that you have a reason and a method to regularly assess how, where, and how long personal information from consumers is stored in the regular course of your business. And generally, you're going to aim to retain personal data only for as long as is necessary for your business. And that may be dictated by outside elements, such as the type of information that you're dealing with, whether that's medical, financial, employment information. There might be outside regulations that come into play there. But in terms of your data retention schedules, you want to establish regular reviews of your retained data so that you always know what kind of data you have on hand, who it's from, and when you should be looking at purging it. And in terms of purging, you should have clearly outlined methods for erasing data, or if you are a company that chooses, that is not required to erase data and chooses to keep it on hand, you should have a clearly outlined method for scrubbing it of personally identifying information that can link that data to a specific individual.
So Micole covered several things that are internal to your company or external in the sense that it's something that you might put on your website. But it's also important to know what contracts with your business partners, your vendors, individuals that or companies that are doing work for you say about data privacy and the obligations of the parties to those contracts. Contracts can have, as simple provisions as confidentiality that require you to keep data or information confidential, up to provisions that cover things like cross-border data transfers. All of these have data privacy implications, and it's important to sort of understand what those requirements are in any given contract you've got with another business. Some of these can be more onerous than others. Give an example. We're seeing more and more audit provisions that have to do with data privacy in vendor contracts now. That require that there are a purport to allow a company to audit a vendor's processes on a regular basis or at will. And if these are overlooked and they're called upon, they can be quite the hassle to the companies that are having to deal with these issues. Some of the reason we are seeing these provisions more and more in contracts is because the laws, the comprehensive data privacy laws that we've discussed, including and some of the industry specific laws that we touched on, require these types of provisions in contracts or separate contracts. For example, the GDPR and the CCPA both have requirements for written agreements with individuals or companies that are processing your data or processing the data of your consumers. In the HIPAA space, there has long been business associate agreements. So the medical industry is relatively familiar with these types of agreements, but they are popping up in many other areas. It's also something that you see a fair bit in government contracting because there have been since the 70s requirements on government agencies with respect to privacy. Next slide, Micole. Finally, something that all businesses and organizations should be considering is cyber insurance. This 10, 15 years ago, cyber insurance was not something that most brokers knew about or really advertised, but it's become prolific in the insurance industry. I think cyber insurance is important. It can cover a number of things in the event of a data security incident, from in a ransomware where you're shut down for a number of days. It can help cover for business disruption. It can help cover the cost of professionals, attorneys, forensic analysts, and others who assist during a data breach. It can help cover the cost of notification, which, if you're having to give notification to a large number of individuals, can be expensive. It can help pay ransom in some instances. It can also help with PR and fallout after a data breach. We get asked, relatively often, do I really need to get cyber insurance? I can pay for this when it happens. The cost of a data breach, really does vary quite widely. I've given on the slide, two averages. One is from an IBM annual report. This looks at sort of global data breaches and includes, breaches at the biggest companies in the world. The estimate there is that the average is 4.24 million, down to a number by Kaspersky, which is focused on small businesses and the cost of data breaches in the small business space. The average there is 105,000. I have certainly seen that number hit by in breaches for clients. And so most small businesses to medium-sized businesses don't have that kind of money available and around to pay. So it can be helpful to have cyber insurance. It's important. You can manage the cost of cyber insurance by doing many of the things that we've talked about in the past couple slides, putting in place written information security plans, data retention schedules. Those sorts of things can help bring your premiums down. So it's important for that reason as well to go through these processes. All right. We have just gone over the hour mark, and we are happy to answer any questions that folks may have. We'll give it a second and see if anyone has any in the chat box. Well, I'm not seeing any, so I think that we are wrapped up. Got one more slide, Micole, to advance. Oh, there we go. Wait a minute.
We have a couple that.
Yep.
just popped up.
All right, that's the common question. Yes, we will. The slides will be available, as will the recording of the presentation tomorrow. I believe they should be sent out to attendees at that point once the recording is processed and able to be loaded. So thank you for participating. We appreciate everyone who stuck with us. If you've got questions or want to follow up with us, our information is on the slides, and we look forward to hearing from you. Thanks.